Okay, school district submitted a proposal to parent with setting for placement. I'm guessing that means a self-contained environment. That typically is what a for designator across the states, but I don't know where you live. So I'm guessing setting for placement would be a self-contained special education classroom. During the IEP meeting, SPED director said that they wouldn't negotiate on that. Okay, and their decision was firm. Now my question on that is that when you develop an IEP, do not talk about placement at all until you're done developing the IEP. All right. Otherwise, the school risks legally being accused of what's called predetermination. They cannot predetermine a placement, meaning you don't develop the IEP to fit whatever you want with regards to where the child's education is going to happen. All right. That's predetermination. The legal standard is that you presume competence and you presume that the child can be successful in the general education setting to the maximum extent appropriate. Now, appropriate is that word, okay? I don't know. That would have to depend upon the child's evaluations, the data collection within the classroom. If the child's behavior impedes their learning, mainly the learning of other students, to the point where it is overly disruptive and cannot be accommodated or reduced effectively through a positive and appropriate behavior intervention plan. And then depending if the child is considered severely cognitively disabled, then that's another justification to where that maximum extent appropriate in general education can be chipped away and reduced. All right. As far as putting that IEP together, you have to develop the IEP before it leads the team to where that IEP can be implemented. Okay, follow me on that. You develop the IEP first. The goals, the services, the accommodations, the supplemental aids and services, all of those things have to be considered. You put that together. And then that should be very clearly to the IEP team where that IEP can be implemented. Most IEPs can be implemented basically anywhere. But depending on the nature of the child's disability, it starts to contract depending on their needs to the point where now we're reduced to a few settings, meaning a self-contained special education environment is where this IEP can be implemented. Others, the needs are so great, for example, that it's not even in a child's home school. They have to go to a different school within a district to where that's where the additional resources are that don't exist at the child's home school. So there's a whole bunch of different factors involved in this, but by and large, you do not make a decision on the child's least restrictive environment or placement until you are done completely developing that IEP. And this is where a lot of schools make that mistake to where they want the child over here. And so therefore they develop that IEP in such a way to where they manipulate that outcome. That outcome is manipulated by how the school team develops that IEP. Now, that doesn't mean that the parent isn't without options. That's what due process complaints are for. And if you submit a due process complaint, then you can request stay put. And stay put would basically designate that I have a disagreement with this, how this IEP was developed, and I have a disagreement with the IEP team, on the IEP team, that there was predetermination. I can show that this isn't an appropriate environment for my child. I mean, there's a whole bunch of different factors that you can put in, but you can stop that from occurring in the short term by filing that complaint and asserting stay put. And what would happen is that it would revert back to where the IEP team for the short term would have to use the last agreed upon IEP, the last one where there was consensus to where everybody agreed, while this one is under scrutiny and maybe requires a hearing to have a hearing officer make the determination of appropriateness and whether a free appropriate public education was offered or could be provided within that IEP. Okay, that's how all of that works. So let's read the rest of it. If the parent were to object to the proposal, the district is ready and willing to go to due process. That's what they tell you. But that doesn't necessarily mean that they want to go to due process. Due process is expensive for school districts. And usually they're blowhards about those kind of things. There's always room to negotiate unless you have a very nasty school system. There's always middle ground. And this goes for parents too. Try to always identify the middle ground. These aren't death penalty cases, okay? This is about services, this is about programming for your child. Try to identify and negotiate. But people that are so stuck in their positions can never identify what might be in between that will work for everybody, and especially for your child. Now, I'm not saying that that's the case here. I'm answering the question off of very basic information. There is also a state complaint on hold because the district asked for mediation. They wanted to do the mediation through the Office of Administrative Hearings and not Department of Education. That's not uncommon, guys. The Office of Administrative Hearing Officers, whichever one, the mediators are basically coming from the same place, or they should. I don't know what state you live in, so that's the other thing. What would be your recommendation in this whole situation? I don't have enough information to definitively tell you that this is predetermination, but it sort of sounds like it. And if that's the case, then I would have filed a due process complaint immediately in order to assert stay put. As for evaluations, the evaluations are the things that in the data collection are going to be the things that you would need to prove the opposite of whatever the school is trying to assert. Okay, now mediation isn't a bad thing. You still maintain your rights going through mediation to be able to file a due process complaint. So you're really not losing anything if you're a parent and the school district wants to go to mediation. You just have to be careful that if you sign a mediation agreement at the end, then yes, it does eliminate all of your prior complaints to the point where you sign that mediation agreement. So you got to make sure that you're getting something good out of the deal before you put your signature on it, because that would basically start you over again from scratch with regards to your child's rights and being able to advocate for them moving forward. Okay?